So here's the $1,000,000 question. Which Katy is more Perry? I'm Andrei Mincov, the founder of Trademark Factory. And in this video, I'm going to share my thoughts about yet another trademarking screw up. This time around, it's Katy Perry suing Katy Perry in Australia for trademark infringement. All right, let me start by reading from the article, and you can always find the link in the description below. Katy Perry sued by Australian designer Katy Perry over trademark. Katy Perry and Katy Perry, so one with a Y, the other one with an IE, who both have a clothing line, will go head to head in a David and Goliath fight. All right. Singer Katy Perry is being sued by Australian fashion designer Katy Perry for trademark infringement. Describing it as a real David and Goliath fight, Ms. Taylor said, "The singer has ignored my trademark and continued to sell infringing goods unlawfully in Australia." All right. So this is Katy. So this is Australian fashion designer Katy Perry's second run-in with a singer, right? That's a weird photograph. Do what you want with me. That's a weird photograph. But anyway, I am fighting not just for myself, but for all small businesses in this country who can be bullied by these overseas entities who have much more financial power than we do. I have something to say about Australia. I don't know why it has to be Australia all the time, right? They had Burger King that couldn't get their trademark in Australia. They had other brands. We had our run-in with somebody who stole Trademark Factory's brand in Australia. Lots of fun there in Australia. I don't know why it has to be Australia all the time, but let me keep reading. The challenge comes after the singer's clothing line was launched across Australia. It's the second time the two Perrys have come to grief over their shared name, with a fireworks singer attempting to stop the designer from trademarking her name back in 2009. The designer's legal team claimed the singer tried to bully her in that case via her lawyers, threatening to sue her unless she gave up the name. And the case was later withdrawn. However, the boot is now on the other foot. Sydney's designer Perry is using her married name of Katy Taylor to pursue the case. So the mother of two says it has only been made possible thanks to legal funding through Global Litigation Fund or Litigation Capital Management. The designer, who had previously worked in London, started her company in 2006. She has owned the trademark registration for Katy Perry branded clothes in Australia for the last 11 years. Okay, so this is, again, one of those cases when bad facts could make bad law, right? We've got a really weird situation, one of a kind, when you have two people with virtually the same name, one of whom is a designer few people have ever heard of, and a singer that a lot of people have heard of worldwide. And the problem with that is that the designer has had her trademark for a long time. So it's a well-established trademark in Australia held by a designer few people have ever heard of versus the same name of a singer that a lot of people have heard of. So who is supposed to walk away with the right to use the name for a clothing line? And there's no good answer here. There's really no good answer because, like I said, bad facts could potentially make really bad law. Because here's what we're choosing from. If we go straight to the letter of law, right? We have to pick one because trademarks, like all intellectual property, is all about exclusive rights. It's all about monopoly. It's all about the right to exclude everyone else from the right to use a certain name, a certain logo, a certain tagline in connection with certain products. So unless these parties can come to certain terms as to who can do it and how they can do it, how they can coexist, it would always have to be one or the other. So how do we choose between somebody who has owned the trademark for 11 years, someone who has the name, which is the same name as the singer? It's her name. She's had the trademark for 11 years. Would it be right for the court to say, well, you know what, the singer is more famous than you, so screw you and your trademark, we're just going to give it to the singer? That would not be right. But on the other hand, we have a situation when the singer is known worldwide. She's got her trademarks in a bunch of countries. She's got a clothing line, and I'm sure that a lot of fans in Australia want to buy the singer's clothes because they like the singer more than they like the designer. So should the court say, screw you, singer, you cannot bring your clothing line to Australia because we already have one of our own, Katy Perry designer, who owns the trademark for clothes, right? You see, both options are pretty bad. And it would give the judges a pretty hard time picking which would work better, which would create a better outcome. But if you forget about the singer and how well she's known around the world, you get to the situation when the Australian person, an Australian designer, owns an Australian trademark, has owned this trademark for 11 years. There is really no reason why she wouldn't be able to enforce that trademark. So if this is resolved strictly in a court of law, there is probably no way for the singer to win, and she'd be precluded from selling her clothes in Australia. What the singer could do is basically trademark her brand everywhere outside of Australia, and then go after the designer if the designer tries to sell her clothes anywhere outside of Australia. So probably the better outcome would be for these two to come to certain agreement, certain arrangement whereby they can coexist without killing each other, and just go from there. Because really nobody benefits from this market confusion, whether it's Katy with a Y or Katy with an IE. It looks like one of them would probably have to change the brand, and I'm guessing it will not be the singer. But if the singer made a good enough offer to the designer might probably change her brand and basically make more money on that transaction than her entire clothing line would ever make her. This is my guess, just a business decision. But if they can't agree to a business decision, then I guess the situation will be very simple. The singer will not be able to sell her clothes in Australia, and that will be the end of that. And the designer is always going to be able to say, I was able to prevail with my trademark in Australia, and I was able to win. And one thing I want to say before I finish this, this analogy with David and Goliath is really first of all, it's getting tired. But when you have a trademark, you're not really a David. Often you are the Goliath, because the trademark, the registered trademark, gives you so much ammunition against anybody else. They may be $1 billion company, they may be a really well-known singer or a really well-known company, a very established company, but if you have a registered trademark, that's more ammunition than all of their money, than all of their lawyers. So stop this nonsense with David and Goliath if you're the one holding the trademark. If you hold the trademark, you are the Goliath. So it doesn't make you good or bad. It doesn't make you, a victim or the victor. But what it does give you is the ability to fight, right? That's what trademarks are for. In fact, trademarks and intellectual property, the whole idea of intellectual property is to help the little guy fight against the big guys, because big guys, they don't need intellectual property as much as little guys do. Big guys have all the money in the world that they can spend on advertising and lawyers, right? That's what little guys can't do. So in order for the little guy to compete with the big guys, in order for the little guy to survive the attacks from the big guys, they need intellectual property. That's the whole reason why it was designed, and that's why even if you're just starting out, if you're just starting out with your business, if you are just starting to get some traction, you gotta protect your brand, you gotta protect your intellectual property, and you gotta do it early on, because there will come a point in time when it will become too late. I always like to say that by the time you have grown a really successful business, someone will have trademarked your brand. Why not you, right? So go to trademarkfactory.com, book your call with one of our strategy advisors, and see if you're the right fit, see if we're the right fit for you, see if we can help you protect your brand. And if you found this video useful, make sure you subscribe, get notified whenever the next video goes live. Like this video, comment below, and I'll see you in the next video.